What is a succession certificate and how to obtain it from the court? Hello and welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. Today, we will learn about the succession certificate, what it is, why it is needed, and how to obtain it from the court. Let's understand everything step by step with practical examples. What is a succession certificate? A succession certificate is a legal document issued by a civil court that authorizes a person to inherit the movable assets of a deceased person. It is primarily required when a person dies intestate, meaning without a valid will. Now, we will understand why a succession certificate is needed. To establish the legal heir's right over the deceased person's movable property, such as bank balances, fixed deposits, shares, mutual funds, and insurance claims. It helps in avoiding disputes among legal heirs. Banks, financial institutions, and companies often require this certificate before transferring assets to the legal heirs. Example 1. When is a succession certificate required? Suppose Mr. Ramesh, a salaried individual, had a bank account, shares, and an insurance policy. Unfortunately, he passed away without making a will. His wife and 2 children approach the bank to claim the funds, but the bank asks them to produce a succession certificate. Without this document, they cannot access the money. Now, we will go through the legal provisions for obtaining a succession certificate. A succession certificate is granted under the Indian Succession Act, 1925. It applies to Hindus, Muslims, Christians, and other communities, though personal laws may vary. Now, we will understand who can apply for a succession certificate. A succession certificate can be applied for by any legal heir of the deceased, including spouse, husband, wife, children, sons and daughters, parents, father, mother, siblings, brothers, sisters, in the absence of direct heirs. If there are multiple heirs, one person can apply, but all others must give their consent. Example 2. Multiple heirs scenario. Mr. Suresh passed away, leaving behind his wife and 2 sons. His younger son, Raj, applies for a succession certificate, but his elder brother, Amit, raises an objection. In such a case, the court may either require the consent of all heirs or distribute the assets accordingly. How to obtain a succession certificate from the court? Now, let's discuss the step-by-step procedure to obtain a succession certificate. Step 1. Filing a petition in the civil court. The legal heir must file a petition in the district court where the deceased resided or where the assets are located. The petition must include 1. Name, age, and address of the petitioner. 2. Relationship with the deceased. 3. Details of the deceased person, including date of death. 4. List of legal heirs and their consent, if applicable. 5. Details of the movable property assets for which the certificate is required. 6. A declaration that there are no disputes among the heirs, if applicable. Step 2. Payment of court fees. The petitioner must pay court fees, which vary by state. Fees are calculated as a percentage of the asset value. Step 3. Court issues notice. The court issues a public notice in newspapers, giving 30 to 45 days for objections from any other claimants. Step 4. Hearing and verification. If no objections are received, the court verifies the petitioner's claim. If there are objections, a hearing is conducted, and the court decides accordingly. Step 5. Grant of succession certificate. Once satisfied, the court issues the succession certificate. The legal heir can now claim the deceased's movable assets. Limitations of a succession certificate. Now, we will discuss the limitations of a succession certificate. It only applies to movable property and not to immovable property like land or houses. It does not determine the legal heirship permanently. It only gives the right to collect and distribute assets. In case of a will, a probate or letter of administration is required instead of a succession certificate. Example 3. Property inheritance issue. Mrs. Sunitha's husband passed away, leaving behind a bank account and a house. She obtained a succession certificate for the bank funds, but to transfer the house ownership, she had to apply for a legal heirship certificate or mutation in land records. Alternatives to a succession certificate. Now, we will discuss the alternatives to a succession certificate. Legal heir certificate used to establish heirship, often required for government benefits. Probate. If the deceased left a will, the will must be probated in court. Letter of administration. If no will exists, this allows an administrator to manage the deceased's estate. Conclusion. In summary, a succession certificate is essential when a person dies intestate and legal heirs need to claim movable assets. It is obtained through a court process and ensures a smooth transfer of assets. If you or someone you know needs legal assistance in obtaining a succession certificate, consulting a lawyer is advisable. Call to action. If you found this video insightful, don't forget to like, share, and subscribe to Legal Information, Law Insights. Drop your thoughts and questions in the comments below. I'll be happy to answer them. Until next time, stay informed and stay empowered.